Good evening. Happy Monday. Nice to see you again. Long time no see. So, Lane Myers had a hearing this afternoon. I was forced to watch it on the Reluctant Prophet stream because the way Judge Metcalf, I believe his name is, has his live stream set up, you can't rewind it. So, you can only hear what's current, what's going on. And I was in court this afternoon, so I didn't get to watch it live. So, there you go. But in the Reluctant Prophet stream, when he wasn't talking over Lane Myers' hearing, Lane Myers brought up this case, Mendes versus Robertson, and he has filed, I guess today, he filed a new motion for a bail eligibility rehearing. His attorney had filed one previously, uh, and then withdrew it because Lane wanted to file his own and the attorney was withdrawing. So this is going to be Lane Myers' own motion. Sorry, I'm really tired. My eyes hurt. It's going to be Lane Myers' own motion for a bail eligibility hearing. And this was the case he cited for the proposition that essentially he is entitled to a whole new trial. At least that's what I understood him saying. Now let's look at Mendes versus Robertson. There's some things that you should really be aware of. Number one, it's a 2002 case, but Rule 7.4 has been modified at least 6 times since 2017. The language is definitely different. This is the language that was in what was then Rule 7.4b, which is now Rule 7.4c1. The language is different. It used to be any person remaining in custody may move for reexamination of the conditions of release whether the person's case is transferred to a different court or the motion alleges the existence of material facts not previously presented to the court. Now it says, on motion or on its own, a court may re-examine bail eligibility or the conditions of release if the case is transferred to a different court, if a motion alleges the existence of material facts not previously presented to the court, or if the defendant is unable to post bond due to the defendant's financial condition, the court may hold oral argument or evidentiary hearing. The reason why the defendant, Mendes, won at least one of his motions, one of his appeal points, was that he alleges that the judge applied the abuse of discretion standard in reexamining the release order, and she was required to review the matter de novo. Now, I don't think that Lane Myers understands this distinction. Abuse of discretion is a appellate style review, where you look at what the prior court did, and where the reviewing court looks at what the prior court did and sees if they abused their discretion. Courts have a lot of discretion, and the abuse of discretion is a very high bar for the appellant to overcome. Basically, the court looks to see if there's any justification that a reasonable judge would be able to use to arrive at the decision that the trial court judge arrived at in the normal appeal case. In this case, it's just a different court looking at it, and they're both trial level courts. But you get my point. Abuse of discretion is normally used in an appeal where the appellate court will look to see if there's any justification that a reasonable judge could have used to arrive at the conclusion that the trial court arrived at. It's a very high bar. And what Mendes proposed and what the Court of Appeals agreed with was that the court, instead of looking to see if the trial court abused its discretion, the new court was supposed to basically make a new decision independent of the previous court's decision. They're not really reviewing the decision. They're just looking at all the facts and making their own decision. So it's a much lower bar. Basically, it's like a do-over. Instead of you have to show that the trial court really effed up, it's just a do-over. And yeah, so it's just a do-over. But how does that help Lane Myers? And to answer that, I have to say I don't know. I have done quite a bit of looking to see if Mendes versus Robertson or any other case requires the court to give a new hearing, a new eligibility hearing. And I can't find any that says it does. Now, if you look at the language of the statute, it says on motion or on its own, a court may, which is permissive, not mandatory. It doesn't say the court must. It doesn't say the court shall. It doesn't say the court will re-examine bill eligibility. It says the court may. It may not. And it also says the court may hold oral argument or an evidentiary hearing. First of all, the court may either hold an oral, if it decides to allow the re-examination, if it decides to re-examine it, the court can do it by oral arguments or evidentiary hearing. And that is consistent with Mendes, because in Mendes they didn't have that language apparently. But Mendes said he was entitled to a new evidentiary hearing, and the respondent judge just gave a oral hearing, oral arguments. And they relied on avowals by the prosecutor. So the prosecutor can say, like, the victim felt this way or that way. The victim saw this, the victim saw that. These would be avowals by the prosecutor, and the court can rely on that. You're not entitled to all of the rules of evidence at one of these rehearings. So that wasn't an issue. The court said, no, you don't. The court can rely on the avowals. The court doesn't have to provide you with the victim for cross-examination. So basically, what the court can do, first of all, what the court can do is the court can say, you know what, I don't want to re-examine it. The court doesn't have to re-examine it. The court can refuse to re-examine it. The court can say there's nothing new or exciting or different that is going to come of this. It's just a waste of time. I'm not going to re-examine it. Now, I'll bet you the court will re-examine it, and that's fine. But I also bet that the court won't do the full evidentiary hearing. The videos and the voicemails and things like that speak for themselves. Or no, for the second one, it's just the videos. The videos that speak for themselves. The court can go and examine the videos on its own and decide whether or not they meet by proof evident or presumption great. Let's see if I got that right. Proof evident or presumption great. Proof evident, presumption great. That he's not eligible for bail under Rule 7.2b2, where he's alleged to have committed a felony while out on pretrial release. So if it appears to be that way, so the court, so what this court can do, what Metcalf can do, is say, look, I've seen the videos, or I'm going to go review the videos, or I'm going to listen to just oral argument, and then I'm going to make my decision based on that. It doesn't mean that would be enough for a de novo. He doesn't have to allow evidence to be presented. He can just say, look, make your argument on declaration or on prosecutor's avowal, and we'll just do this orally. We don't have to do a whole evidentiary hearing. So I don't know how that's going to help Myers, because again, the court has a lot of flexibility there. But then the problem is the court's also still going to find that there's proof evident, presumption great, that Lane Myers was harassing the victim. And I know Lane Myers fans are going to completely misinterpret this, but Lane Myers has gone out of his way to be a prick to the judge. And the judge is probably going to take that into consideration when he's reviewing any evidence or listening to oral arguments. Let's see, this guy who can't control himself in my courtroom and who's just a complete ass to the prosecutor and to me and to his attorney, and who thinks everybody's retarded except for him, and who thinks he understands the law when he clearly does not, is going to argue that he was not, in fact, harassing the prosecutor's wife. Yeah, that's going to be a tough one for the judge. Boy, I don't know how the judge is ever going to make that decision. But yeah, his current courtroom behavior is going to prejudice the judge against him, because why wouldn't it? Why wouldn't it? If you can't control yourself in the courtroom, why would the judge think you're controlling yourself out in public on YouTube, making phone calls, et cetera, et cetera? Anyway, I don't see a great. First of all, his legal argument is lacking. I do think Lane Myers is going to get the hearing because the judge, in an abundance of caution, will probably give him the hearing. Uh, I'm going to guess it's going to be an oral argument. Uh, Oral argument. I don't necessarily think the judge is going to allow for more cross examination of the detective. He might. I 99.9% sure he's not going to allow any examination of the victim. The court may review the video snippets provided by the prosecutor, but at the end of the day, Lane doesn't understand what he's looking at when he's looking at Mendes versus Robertson. That's step number one. He doesn't understand the language in this motion where it says the court may do it and the court may hold oral argument. He doesn't understand the difference between a de novo review and an abuse of discretion review. And he doesn't understand that his videos are not something that is going to convince a judge or a juror, your average juror, your average non-Lane Myers supporter. Basically, his videos are incriminating. His videos are incriminating. They're not exculpatory. He seems to think they're exculpatory, but they're not. Anything you say can and will be used against you. Nothing that you say can be used for you, Lane. There's those two things aren't like bound together. Anything you say can and will be used against you does not mean that anything that you say can be used for you. Your videos are incriminating, not exculpatory. Anyway, that's all I got for you today. Thanks for watching. Have a great day.